Ready? Ladies and gentlemen, welcome to the third of the 2021 RDS Public Law Series with a former Justice of the Court of Appeal, Dato Seri Hishamudin Yunus. Judge Hisham began this series by discussing about the constitutional right to property. Judge Hisham, together with a guest speaker, Dato Sri Gopal Sri Ram, highlighted that the right must be construed widely to include intangible business goodwill and even a right to employment. In the second session, Judge Hisham was joined by Professor Asmi Sharon, the Deputy Chairman of the Elections Commission, where they discussed about the extent of a person's right to education, a right enshrined in Article 12 of the Federal Constitution. Today, Judge Hisham will be joined by Tan Sri Dato Mohd Ariff Yusof to discuss about the role of the judiciary in upholding the Constitution and the rule of law. Judge Ariff has an illustrious career. He was a lecturer in the University of Malaya. In 2008, he was appointed as a High Court judge and then elevated to the Court of Appeal 4 years later. And in 2018, he even became the Speaker of the Dewan Rakyat. Today's lecture is titled Judicial Activism. Judge Hisham, it gives me great pleasure to now pass the floor over to you. Judge Hisham.
Thank you, Moderator, Mr. Hayden Tan. Salam sejahtera and a good afternoon to all members of the audience. First, I would like to thank my firm, Rushdie Dahlan, Saravana Law Partnership, for inviting me to be the keynote speaker for this afternoon's webinar on the interesting topic of judicial activism. I'm indeed honored. And I'm delighted this afternoon for having the honor to be with my learned friend and guest speaker, Tan Sri Mohd Ariff Yusof, who will share his knowledge and thoughts on the subject. But to begin with, what is judicial activism? Judicial activism is not an easy term to define. It is a term that is at times poorly understood and occasions associated with negative connotations. In this presentation, I do not propose to offer a definition of the term judicial activism. All that I wish to say is simply this. Judicial activism is a term that describes a judicial decision that is creative, that breathes life into the law, a decision that involves inductive reasoning, that is positive and takes into account the social needs of the time, whilst at the same time paying heed to the principle of justice and the legal and the constitutional framework within which that decision is made. Actually, the term judicial activism is relatively new. When the term judicial activist first appeared in print only in the year 1947 in a Fortune magazine by one Arthur Schlesinger Jr., an article about justice of the Supreme Court. Be that as it may, the truth is that judges have been making judicial decisions that manifest judicial activism for a long time, even before the celebrated case of Marbury and Madison. Indeed, I would say judicial activism is as old as the common law. Yet there was a time when some judges and writers subscribed or advocated the theory that the function of judges is merely to interpret the law and nothing more than that. For example, to the French political thinker Montesquieu, judges were, quote, only the mouth that pronounces the words of the law, inanimate beings who can moderate neither its force nor its rigor, unquote. And in 1944, an English law lord, Lord Green, writing in the Law Journal in 1944, perpetuated the myth or fiction when he said, quote, the function of the legislature is to make the law. The function of the administration is to administer the law. And the function of the judiciary is to interpret and enforce the law. The judiciary is not concerned with policy. It is not for the judiciary to decide what is in the public interest. These are the tasks of the legislature, which is put there for the purpose, and it is not right that it should shirk its responsibilities. However, another English law lord, Lord Reed, in an article that he wrote in 1972, debunked the fiction that judges do not make law. I quote, there was a time when it was thought almost indecent to suggest that judges make law. They only declare it. Those with a taste for fairy tales seem to have thought that in some Aladdin's cave, there is hidden the common law in all its splendor, and that on a judge's appointment, there descends on him knowledge of the magic words, open sesame. We do not believe in fairy tales anymore. I just observe here, I think the learned law lord have mixed up Aladdin and Alibaba. Aladdin doesn't have, it's not actually with the cave, it's Aladdin and his magic lamp. And open sesame and the cave is linked to Alibaba and his 40 thieves. But nonetheless, these two tales are from the Arabian tales of 1001 Nights. Yeah? Perhaps it would not be wrong to say that today, few lawyers subscribe to the view that judges do not make law and that they merely interpret the law. Be that as it may, it is however true that judges do not make law every day in their daily work. In dealing with the mundane, run-of-the-mill sort of cases, judges merely interpret and apply the law to the facts of the case. But there will be occasions, perhaps not often, where he is confronted with a peculiar situation where the written law is ambiguous, where there's a gap in the law and there are no precedents to guide him, where there's a strong conviction on his part for the need to propound a new principle of law in order to do justice to the case, or in the case of judges sitting in the apex court, there's a need to depart from precedents in keeping with current situation of prevailing conditions and social values. It is in such situations that judicial activism comes into play. I will now come to judicial activism and the American experience. The Supreme Court of the United States is the oldest constitutional court in the world, having first assembled on the 1st of February 1790. At a very early stage of its existence, that is in the year 1803, it bestowed upon itself the power of judicial review through the epoch-making decision in the celebrated case of Marbury against Madison that I've mentioned earlier. In this presentation, I propose to invite you to revisit this famous case. This is a classic case of judicial activism. To understand the case is to understand what judicial activism is about. Americans are proud of the judgment. To them, it is a national treasure. The judgment is displayed in the National Archives in Washington, D.C., next to the Declaration of Independence, the Constitution, and the Bill of Rights. The paintings of William Marbury and James Madison hang prominently in the Supreme Court Justice private dining room. To the Americans, the decision is one of the cornerstones of the American constitutional system. This is the first case in American legal history where the Supreme Court struck down an act of Congress as unconstitutional. After Marbury, it was 50 years before the Supreme Court again declared an act of Congress unconstitutional. And this is how the great decision came about. You have to bear with me on the facts, yeah? In February 1801, in the last month of office, President John Adams, the second president of the United States after President George Washington, submitted about 200 nominations to the Senate. The appointment included 93 judicial and legal officers. William Marbury was one of those appointed by President John Adams, who was appointed as a justice of the peace. But very soon after the appointment, President John Adams was succeeded by President Thomas Jefferson, who became the third president of the United States. Marbury did not receive his commission, so he filed an original suit in the U.S. Supreme Court asking the amendments be issued to James Madison, the Secretary of State, commanding him to cause to be delivered to him, Marbury, a commission as Justice of the Peace. The Supreme Court, presided by Chief Justice John Marshall, ruled that Marbury had a right to the commission and that his right had been violated because the commission had not been delivered to him as required. It also ruled that he was entitled to a writ of mandamus directing Madison to cause to be delivered to Marbury the commission he sought. But the question arose as to whether the Supreme Court had the power under the Constitution to cause the mandamus to be issued. The Judiciary Act of 1789 authorized the Supreme Court to issue writs of mandamus in cases warranted by the principles and usage of law to any court appointed or persons holding office under the authority of the United States. The Act therefore clearly empowered the Supreme Court to issue a writ to the Secretary of State Medicine. This is what the Act provides. However, there was a problem, and it is this. The Constitution of the United States declares in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. It was clear, the Supreme Court explained, that this was a case of original jurisdiction and that the court had no jurisdiction under the Constitution because the case did not come within the scope of original jurisdiction as set out in the Constitution. Thus, the Constitution prohibits which the Judiciary Act had granted. That is the power to issue a writ directed to Madison. The Supreme Court went on to hold that the Constitution, vis-a-vis a federal law enacted by Congress, is a superior and paramount law and is a supreme law of the land. And the court held, I quote, it is emphatically the province and the duty of the judicial department to say what the law is. Since the Constitution is a supreme law of the land and declares that the Supreme Court has no jurisdiction in Marbury's case, the Supreme Court held it must declare the statute, which is contrary to the Constitution, unconstitutional and void. But there's a problem here. There's a problem with such a ruling in that nowhere in the Constitution of the United States is it stated that the judiciary has power to declare acts of Congress unconstitutional. Members of Congress are required to pass laws consistent with the Constitution, and the laws they pass must be signed by the President of the United States only if they preserve and protect the Constitution. All three branches of government have a duty to act constitutionally. The Constitution does not say that the judiciary's view of the Constitution prevails over the legislative and the executive view. Chief Justice Marshall had read into the Constitution a provision that simply was not there. Therefore, one could say that the decision in Marbury and Madison was a manifestation of judicial activism. The Supreme Court was reading into the Constitution an important provision that was not there. Among famous examples of judicial activism cases are Brown against the Board of Education, is about the racial desegregation case in schools, and Roe against Wade, a case concerning a person's rights to abortion. Now I'm having discussed the American experience, I now move to the Indian experience on judicial activism. During the initial years of its existence, the Supreme Court of India adopted a conservative approach. This is evident in some of its ruling, for example, the ruling in the case of Gopalan against the state of Madras, where the Supreme Court was called upon to consider adopting the American doctrine of procedural due process, but the Indian Supreme Court declined to do so. However, subsequently, there was a change in judicial attitude. A clear example of this change in approach is the landmark case of Kesavananda Bharata against the state of Kerala. In this case, the Supreme Court propounded the basic features doctrine. The doctrine propounded is to the effect that there is an implied restraint on the amending power of Parliament so that the power could not be exercised to destroy the basic structure of the Indian Constitution. The basic features are, firstly, supremacy of the Constitution. Secondly, republican and democratic nature form of government. Third, secular character of the Constitution. Fourth, the separation of power. And fifth, federalism. But in enunciating the above principle, there is a problem. There are no express words in Article 368 of the Indian Constitution limiting the power conferred by that article on Parliament to amend the Constitution. There are no express words that state Parliament is not entitled to amend the Constitution in such a way as to alter or affect the basic structure of the Constitution. So therefore, the decision is a remarkable instance of judicial activism. A former Chief Justice of the Indian Supreme Court, A.M. Ahmadi, in his article, Dimensions of Judicial Activism, advanced the following concept of judicial activism. Quote, simply put, judicial activism depicts the proactive role played by the judiciary in ensuring that rights and liberties of citizens are protected. Through judicial activism, the court moves beyond its normal role of a mere adjudicator of disputes and becomes a player in the system. Laying down principles and guidelines that the executive must carry. In performing its activist role, the court is required to display fine balancing skills while protecting the fundamental human rights of the people. The judiciary must take care to ensure that its orders are capable of execution, for no amount of judicial activism is useful if its orders are incapable of execution. They then remain paper tigers only. This places an awesome responsibility on the court, which must ensure its directions are effective. Unquote. The activist role of Indian judges is prominent in the field of public interest litigation. The Supreme Court of India, in its endeavor to help the poor and needy and to vindicate the violation of their fundamental rights, has given a liberal interpretation of the locus standi rule so as to enhance access to the courts. For example, the case of Gupta against the Union of India. In this regard, it is of interest to note what Justice Pandyan, a former judge of the Supreme Court of India, in the L.K. Jha Memorial Lecture said about judicial creativity in India. He said, I quote, in a country like ours, where more than 80% of the people are economically backward and they are subjected to discrimination as a rule, in such an explosive situation causing adverse effect on society, when the executive and legislature are apathetic and fail to discharge their constitutional duties and deliver the goods, the apex court, which is the custodian of the citizens' rights and liberties, and which in that capacity acts as sentinel on the qui vive, has no other choice but to step in and direct these constitutional functionaries to discharge their obligation. Unquote. A Malaysian judge or an English judge may not necessarily share the above concept of judicial activism. From India, I now move on to judicial activism in the United Kingdom. Francis Bacon, who was at one time the Attorney General and Lord Chancellor, in one of his essays of judicature remarked, quote, judges ought to remember that their office is just dicere and not just dare. How I got my Latin correct. To interpret the law and not to make law, else it will be like the authority claimed by the Church of Rome. Unquote. So the theory in England, at least from Tudor times, was that judges do not make the law. They only declare what the law is and apply the law to the facts of the case. By the end of the 19th century, Lord Asher, master of the rules in a case called Willis against Badley, perpetuated the fairy tale by saying, and I quote here, "This is not a case, as has been suggested, of what is sometimes called judge-made law. There is in fact no such thing as judge-made law, for the judges do not make the law, though they frequently have to apply existing law to circumstances as to which it has not previously been authoritatively laid down that such law is applicable," unquote. With the proliferation of statutory laws, the above view of the judicial function was reinforced by the positive law theory of Jeremy Bentham and John Austin. The law, according to this positive theory of law, the law was to be found in rules. That's to say, the written constitutions, statutes, and the reasons of judges of the higher courts. The role of the judges was merely to declare what the law was at that particular point of time in relation to the facts of the case. Their function was basically one of verbal analysis and application. Such was the preferred view of most common law judges in England and its colonies well into the second half of the 20th century. But the above view about the role of the English judge was merely a fiction, perpetuated by English judges so as not to appear to have transgressed into the domain of the legislature. The truth is that English judges do make law from time to time since the inception of the common law. In fact, the English judiciary of the 17th century is well known for their judicial activism. And the common law and the principles of equity evolved due to judicial activism. A good example of judicial activism is the case of Dr. Bonham's 1610, when Sir Edward Coke, the Chief Justice, said, I quote, "When an act of parliament is against common right and reason, or repugnant or impossible to be performed, the common law will control it and adjudge such act to be void," unquote. Many scholars view that the decision of Coke, Chief Justice, was an early expression of the doctrine of judicial review and has had a profound influence on Chief Justice John Marshall in Marbury and Madison. An example of judicial activism in English judiciary that is often quoted is the late 18th century case of Somerset and against Stewart. This case is famous for this fact. In England, slavery was abolished, not by the executive or by parliament, but by the decision of a single judge, namely Lord Mansfield. Prior to Lord Mansfield's classic judgment, slavery was considered lawful in England and her colonies. There was no legislation on the matter, but the legality of slavery was based on the joint legal opinion of the Attorney General and Solicitor General given in 1729. So in 1729, both the Solicitor General and the Attorney General gave a joint opinion that slavery in England was legal. Now, Lord Mansfield in his judgment was troubled by the impact on commerce if the slave was set free. Nevertheless, in the case before him, there's a case of a Negro slave by the name of James Somerset. who sought a ruling on the legality of slavery in England. Lord Mansfield boldly ruled, courageously ruled. I quote, "The state of slavery is so odious that nothing can be suffered to support it but positive law. Whatever inconvenience, therefore, may follow from the decision, I cannot say that the case is allowed or affirmed by the law of England, and therefore the black must be discharged." The black means the slaves. The slaves must be discharged. There is the famous saying in the case attributed to Lord Mansfield. I quote, "Every person coming into England is entitled to the protection of our laws, whatever oppression he may heretofore have suffered, and whatever the color of his skin. The air of England is too pure for any slave to breathe. Let the black go free," unquote. As a result of the judgment of one single judge, Lord Mansfield, 14,000 or 15,000 slaves in England were freed. Although there is a marked display of judicial restraint by the English judiciary in the first half of the 20th century, however, there has been a noticeable judicial activism in England, particularly in the field of administrative law since 1960s. A clear example is where the English courts introduced the principle of natural justice in the context of administrative law. The courts hold that administrators who implement the law must comply with this principle of natural justice. Otherwise, the court will declare the action in question as being ultra-virus and hence null and void. Broadly speaking, there are three facets of this principle of natural justice, namely, number one, the right to be heard by an unbiased tribunal. Number two, the right to have notice of the charge. And number three, the right to be heard in answer to those charges. This principle of natural justice was propounded in the landmark case of Rich against Baldwin. In this case, the chief constable of Brighton was charged with and tried for conspiracy. He was acquitted, but the police board summarily dismissed him nonetheless, purportedly under a statutory provision, which gives the board the power to dismiss any borough constable whom they think negligent in the discharge of his duty or otherwise unfit for the same. He brought an action to challenge his dismissal on the ground that it violated the principle of natural justice, since he was never given notice of the charges against him, nor allowed to present his case before the board. The House of Lords upheld his claim and ordered his reinstatement. Judicial activism in England is also exemplified by the House of Lords cases of Padfield against the Minister of Agriculture. Another case is Secretary of State for Education against the Thameside Metropolitan Borough Council. In 1966, in Conway and Rimmer, the House of Lords effectively acknowledged its lawmaking role through the development of the common law by holding that it was no longer bound by its earlier decisions. But it is not only in the field of public law that decisions in which elements of judicial activism are found. Judicial activism is also found in the realm of the law of torts. A classic example is the neighbor principle of the law of negligence in the landmark case of Donoghue against Stevenson, the famous snail and ginger beer case. Donoghue against Stevenson is a great judgment. Lord Atkin's speech in the House of Lords, propounding the neighbor principle, captures the hearts and minds of lawyers. This is how he eloquently puts it. I quote, "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answer seems to be person was so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the act or omissions which are called in question, unquote. The facts of this famous case took place in a cafe called the Well Meadow Cafe, located in a town called Paisley, a small town near the city of Glasgow in Scotland. At this cafe, on 26th of August 1928, one Mrs. May Donoghue of Glasgow was served with ginger beer from a bottle in which she claimed that she later found a snail. Mrs. Donoghue sued the manufacturer, David Stevenson, whose factory was also in Paisley. He denied her allegation. The case, remarkably, the case never went for trial, and it was never decided whether there was a snail in the bottle. It was on an unsuccessful preliminary application to dismiss Mrs. Donoghue's claim that Lord Atkin gave the judgment in the House of Lords, which would make Donoghue and Stevenson the most celebrated case of all time, not only in the United Kingdom, but for the whole of the Commonwealth law world. Lord Atkin's neighbor principle has contributed significantly to the development of the law of negligence. Before Donoghue against Stevenson, the law on civil liability for carelessness was in a chaotic state. In effect, there was no single thought of negligence, but instead a number of separate thoughts, each with its own rules. And the case law on civil liability for carelessness was quite rigidly formulated. If the facts of one's case did not fit comfortably within one of the factual categories in which a duty of care had been held to exist, then no remedy was available. An 1889 textbook listed no fewer than 56 different duties of care. But the judgment in Donoghue and Stevenson brought order to the chaos, and it brought the law of negligence into existence as a separate civil wrong. In conclusion, I would say this. Perhaps it's a fair statement to say that the judiciary, in whichever common law jurisdiction, subscribes to judicial activism. Only that the degree of judicial activism may differ from one jurisdiction to another. Judicial activism, say, in the United Kingdom may not be the same, say, in India. But nonetheless, judicial activism is a reality. It is generally accepted today that judicial activism is a legitimate exercise of judicial function. It is recognized as being part and parcel of the role of the judiciary as being co-equal with the other two arms of government, namely the legislature and the executive, and as being essential to good governance and a system of checks and balance. Judicial experience has shown that there might be an occasion when a judge or a court is thrust into a situation that demands judicial creativity in order to arrive at a just and fair decision. The credibility, integrity, and the wisdom of the judge or court are put to public scrutiny. The activist judge or the activist court must steer through the delicate balancing acts, always bearing in mind and respecting the doctrine of the separation of powers, yet at the same time not forgetting the need for checks and balance and to uphold the rule of law. he must acknowledge that he must not cross the line. I repeat here, he must acknowledge that he must not cross the line. Yet the parameters within which he is to operate are never clear. All that he has to guide him in his difficult task is the statutory provision in question and the constitution, his judicial experience, his understanding of broad principles of justice, and his perception of noble values. And in high profile cases involving the constitution, the judge may even be expected to be both philosopher and king. As a result of judicial activism, inevitably, there would be tensions between the judiciary and the other arms of government, especially the executive. Chief Justice Coke occasionally offended the king, James I, because of his judicial views, particularly his declaration that the king is subject to the law, and that eventually he was removed as Chief Justice of the King's Bench by the king. Coming to the United States, Chief Justice John Marshall was severely criticized by President Thomas Jefferson for the Marbury Medicine judgment. In the mid-1930s, following a series of judicial activism decision of the United States Supreme Court, President Franklin Roosevelt attempted to pack the Supreme Court by appointing more judges, but the plan failed to materialize. At the latter part of the history of the United States Supreme Court, several attempts were made to impeach Chief Justice Earl Warren and Justice William Douglas of Supreme Court. These are judicial activist judges. In India, at a conference of the country's Chief Justices in January 2010, Prime Minister Manmohan Singh voiced his concerns about what he described as judicial overreach, meaning the act of the judiciary in overstepping into the domain of the other arms of government. With that, I end my presentation. Thank you for listening.
Many thanks to Judge Hisham, which gives a good overview and origin of judicial activism. We will now have Tan Sri Ariff to share with us his view about judicial activism. Tan Sri Ariff.
Thank you. Thank you. First of all, as usual, my thanks to RDS Academy for inviting me here. And I'm, of course, always very glad to be in the company of my learned friend, Dato Seri Hisham, who has given a very scholarly introduction to the entire doctrine of judicial activism in the US, India, and the Commonwealth. So my presentation is focused on Malaysia, but I think it very nicely will fit into the points raised by Dato Seri Hisham. Now, of course, like Dato Seri Hisham's early comment on what exactly is judicial activism, it is not something which is very easy to define. Yeah? But first, let me just state what I intend to do. I will trace the historical development in Malaysia on the so-called doctrine or notion of judicial activism, right from the start of our constitution, in fact, even pre-constitutional days, 1950s, to where we are now. So it is not an easy chart to draw, yeah? Because there have been ups and downs, ebbs and flows. But whatever is happening today will reflect what has happened in the past to several jurisdictions, but it will make us think how different we are in Malaysia, or how similar we are in Malaysia as compared to the other jurisdictions. So let me start by looking at the historical development in Malaysia from the 50s to 60s to the 90s and to the current century, meaning now, 2021. In the 1950s, of course, we're looking at strict literalism. In the 60s, we saw small steps being taken to evolve something akin to a dynamic interpretation of the Constitution. And of course, in the 90s, we saw many cases which went further than the early steps. And in the early 2000s, we saw some very remarkable cases being decided. But currently, unfortunately, we have some kind of reversal. I will come to the details of the matter. Now, the first reported case on the federal constitution that I can unearth is Chia Kin Zin versus Menteri Besar Selangor. That's in 1958, just after our independence. Sutherland J held that the constitution could not invalidate pre-existing laws. This was a case of detention under the Selangor Restricted Residence Enactment. So the court took a very literal and simplistic view of its function vis-a-vis the executive authority of the Menteri Besar to order preventive detention, simply held that the discretion was absolute and the court could not challenge it. Very simple. You have discretion reposed in the Menteri Besar, a member of the executive. That discretion is absolute. In the context of restricted residence, the court will not challenge it. And even after that, we have cases which are very restrictive. Surinder Singh Kanda, for instance, government of Federation of Malaya in 1960, it was quite restrictive actually, until it went up to the Privy Council. Privy Council expanded the notion a bit, so now we have the celebrated case of Surinder Singh Kanda versus government of Federation of Malaysia. Until today, is seen as one of the more liberal cases which came to light, but it was decided by the Privy Council. One must not forget it. In Munusami versus Public Service Commission, we have something which rings even today. So it's coming back, this notion of, at the end of the day, the wording of the Constitution itself that is to be interpreted and applied. And the wording can never be overridden by the extraneous principles of other constitutions which are not expressly incorporated in the formulae that have been chosen as the frame of this Constitution. So still a very clear case of literal interpretation of the Constitution. If everything ends there wouldn't be a problem. Judges read the law, apply black letter law, adopt a literal view of the law, and that's it. You can understand it that fully. But of course, the judicial function doesn't operate that way. The legislative function too is not what we imagine it to be. I mean, the so-called collective wisdom of the legislature, some people dub it as a myth. What do you mean by collective wisdom of the legislature that judges have to defer to? Yeah? Well, of course, that is another matter, but we will look at it in terms of the realities of the processes that are involved in governance. You may question whether you should really defer 100% to the so-called collective wisdom of the legislature, or will it not be better for the entire public governance of the nation for there to be checks and balances, and for the judiciary to be vested with powers beyond the strict interpretation of the law? Yeah? And these are the things which we will look at. But in the next slide, I pose the question, what exactly is judicial activism? It's not easy, to come to some consensus on what it is, but Dato Seri Hisham has done an admirable job in outlining some of the salient features of judicial activism. What I was trying to do when I posed this question was to try and detect what judges in Malaysia feel about judicial activism through their judgments. It's not a very easy, search to do. There are not many times that they come up with a definition or they explain what is judicial activism and what we shouldn't do. But in scouring through the reports, I've come across this latest case, Tebin Mustafa versus Hulba Daniel Malaya, which is very interesting. 2020, just last year. And Justice Vernon, the federal court, gave some sort of indication of at least what he feels is judicial activism. Look at this excerpt. Any other interpretation according to the clear words would be to enter into the realm of judicial activism. So he looked at judicial activism head on. Would enter into the realm of judicial activism or legislating, which is never the duty of the courts of law. And there you are, you have a clue. What at least what one judge thinks of what judicial activism is. This judge thinks judicial activism means judges legislating. And of course, it's never the duty of the courts of law to legislate. But is it what we understand as judicial activism? I don't think so. I think in the main, the notion of judicial activism is juxtaposed against that other concept of judicial restraint. When judges take it upon themselves to be too literal, not to be at all creative, and to merely apply black letter law, as if that is the duty of the courts. Of course, it doesn't happen that way. And Dato Seri Hisham just mentioned to us several cases in several areas of the law where it is acknowledged that judges do make law, even within the the interstices of the law when there is ambiguity. They do creatively apply the law in the sense that they advance the parameters of the law, and that is often taken to be the making of law by the judges. But of course, not in a legislative sense. I don't think there is any judge in Malaysia or in anywhere else who will say, I'm making this law. It will amount to legislating the law. No one in his right mind will do it. But when you have laws that are ambiguous and you have to apply the facts to the ambiguous law against a certain setting, in this case, for instance, the setting of the Constitution, judges have to apply their duty creatively and come to a just decision. I think this is what it is at the end of the day. I have also posed another question, because lately it has come to be discussed through the so-called jurisprudence of oath of the courts, oath of the judges. Now, what exactly is the duty of the courts of law? This is something which also appears in that quotation by Vernon and Justice Vernon. It is the duty of the courts. What exactly is the duty of the courts? Looking at the judicial oath with Justice Hisham and myself took when we were judges, yeah, and that is very clearly seen in Article 124 of the Federal Constitution together with the 6th Schedule. Every judge will swear or affirm as follows. I do solemnly swear or affirm that I will faithfully discharge the duties of that office to the best of my ability, and that I will bear true faith and allegiance to Malaysia and will preserve, protect, and defend its constitution. So how is a judge to preserve, protect, and defend its constitution? By adopting mundanely an approach of judicial restraint or a literalist approach. Is it compatible with the judicial oath? I'll just pose that question. And as I hope as we proceed and in this presentation, we can see the anomaly that often arises. You take an oath to defend and honor the Constitution, protect and defend. But when you have a matter that comes before you requiring a just decision in a court with fundamental rights and so on, you take a literal view. You take a conservative view. Is that fulfilling the duty of the courts of law? Something to think about. But anyway, looking at the historical development, This is a slide which I did in another presentation, but I like it so much, I'm reproducing it today. This is from the 1967 edition of Sheridan and Groves. I think this is the first edition. I took a snapshot. You see, it's quite old. Yeah, but in 1967, it's very easy. And the authors said, judicial review of legislation passed after Merdeka Day is specifically provided by Article 4. And it says the law cannot be enforced so far as it is inconsistent with the Constitution. This proposition, which is what one would expect, was not easily accepted by the Malayan courts. This was in 1967, not 1957, 1967. Early days, but not too early, days. But you see the philosophy adopted in Malaysia, even then, it was hardly judicial creativity or judicial activism. But whatever it is, it used to be very easy. When someone writes or studies the judicial decisions of Malaya then, or early Malaysia, it was very easy to surmise that many of our judges, if not most, were literalists. They construe the Constitution very literally, applied black letter law. But things have moved on since then. Obviously, things have to move on. The country changes over time, new problems arises. So let's look at the next slide. Even as early as 1963, Ura, one fine day, we have this case, State of Kelantan versus Government of Federation of Malaya, where the court strayed a bit from the black letter law approach, from the literal approach, to interpret the Constitution in the light of principles. This was something quite new, in the light of principles, but not from the Constitution itself, on interpretation of treaties, because the Malaysia Agreement, of course, involves a treaty. They had to interpret it, and they applied or tried to apply principles on interpretation of treaties. So you could say there was this was a start, somewhat, of the further developments in the 1970s and in the 1980s, where, of course, in step with whatever was happening in the rest of the Commonwealth, we have pronouncements being made all over the Commonwealth on interpretation of the Constitution, how Constitution should be interpreted. So we have all these cases which have been applied even until today, and have been applied by Malaysian courts, but in a way that we least expect. You can apply to all these cases, but you end up with a very narrow approach. But they are not meant to be narrow in terms of the approach. Hines versus the Queen, Minister of Home Affairs versus Fisher, AG of St. Christopher, Nevis and Anguilla versus Reynolds. So notice they were all in the 1970s. And all these cases lay down these basic principles, like I said, which are still applied today. Yeah, a written Constitution is to be interpreted with less rigidity and with greater generosity. It is a living piece of legislation, cannot be construed in a pedantic way. They apply the organic theory. It has to be interpreted organically because Constitution doesn't stop with its promulgation. It has to move in step with developments in the country, in the state. And of course, the Constitution has been repeated endless times, is a sui generis in the instrument. It cannot be treated as a will or interpreted as a national land code. It's sui generis. It's to be interpreted in a different way. And all this has been applied by our local courts, been cited all over in so many decisions. Dato Menteri Osman Baginda versus Dato Ombi Said Alwi. We have the infamous case of Dewan Undangan Negeri Kelantan, Nordin Saleh, notice that Nordin Saleh, referred to all these admirable cases, but the actual decision is something else. It's created problems even until today when they outlawed party hopping. But there you are, it shows you judicial decisions can have a tremendous impact on the country. And the next slide, please. And we see a further strengthening of the organic or liberal approach in the current century. We are, of course, very happy. Those of us who are studying constitutional law, we're very happy to see this development at the turn of the century. With cases like Dr. Muhammad Nasir Hashim, We have cases of Sivarasa Rasya, 2006, 2010, Lee Kuan Wo, 2009, in some sort of way, Dharma Surya, 2010, Ilman, Idham, Kerajaan Malaysia, 2011, and Dato Seri Hisham was on the panel. It was heralded as, you know, as a fantastic creative case of constitutional law. Nik Nazmi bin Nik Ahmad bin PP, where I said, as a member of the panel, we tried to, you know, be creative and come to a just decision. And of course, later on, if we find things were changing, Letitia Bosman, perhaps in a way, versus PP, fitted into the general scope, although this is more controversial, you know, kind of decision. So let's look at what, by way of example, the so-called prismatic approach, thanks to, I think, the argument and the judgment of mainly or mostly Dato Sri Ram, latch on to this prismatic approach. So in Sivarasa Rasya, Lee Kuan Wo, it said this: the Constitution is a document which is sui generis, governed by interpretive principles of its own, something which was already said in the other Commonwealth cases as applying no local courts. In the forefront of these is a principle that its provisions should be interpreted generously and liberally. What follows next is very important. I think now it's been forgotten by many judges. This was what is said in Sivarasa Rasya. On no account should a literal construction be placed on its language, particularly on those provisions that guarantee to individuals the protection of fundamental rights. In our view, it is the duty of the court to adopt a prismatic approach when interpreting the fundamental rights guaranteed under Part 2 of the Constitution. Just so I thought it was a good idea early on to ask what really is the duty and to latch it on the oath taken by the courts. But here you have some indication of what the court in Sivarasa Rasya thought about it. It is the duty of a court to adopt a prismatic approach when interpreting the fundamental rights guaranteed under Part 2 of the Constitution. And of course, taking my own experience as a kind of criterion or yardstick, when the panel decided Nik Nazmi's case, which most I suppose will remember was a case where we held unconstitutional a provision in the Peaceful Assembly Act, to the horror of a lot of people, because we looked at it and there was a tipping point, and we said, no, it has to be declared unconstitutional because it interfered unduly with the right or the freedom of association or freedom of assembly. But in my judgment, I took pains to point out a commentary actually by Michael Kirby, Justice Michael Kirby of Australia. And I would like to look at it again today because I feel that he gives a very good view of what the judicial function should be. This is what Michael Kirby said. By the way, Michael Kirby in Australian circles is often taken to be a very activist judge, whatever activism is meant. He said this: construing a constitution with a catch cry about legalism, with nothing more than judicial casebooks and a dictionary to help, and with no concept of the way it is intended to operate in a nation whose people accept it as a basic law, is a contemptible idea, maybe a bit dramatic, but this is what he said. As one anonymous sage put it, if you construe a constitution like a will and testament, then that is what it will become. You see, if you construe it as a will, it becomes a will is dead letter law, not black letter law anymore. Nevertheless, and this is the caution, nevertheless, legal reasoning, unlike political activism, must always remain attached to legal authority. I think this highlights, a key misunderstanding of judicial activism. Some judges believe that if you raise the issue of judicial activism, it equals to political activism. It is not. Political activism or the legislating of policies or decisions based on politics is qualitatively very different from a judicial decision, creative as it may be, or activist as it may be. The judicial process latches on not a free-ranging range of choices. It must be attached to legal authority. I think those of us who have sat on the bench, who have given decisions which are said to be creative or activist or whatever, have never strayed away from this principle. We are still looking at legal authority. We don't decide on the basis that I will decide this way because I think it is fair. No, that cannot be. No judge will decide that way. There is a certain legal method to arrive at that just decision. So this is what is meant by it's attached to legal authority. Because otherwise the legal function becomes really easy. You will decide as a politician will decide. No, I don't think that is right. So it dictates me, it was stressed following from that citation from Justice Kavi. And again, I'd like to read it. The reference to legal reasoning having to remain attached to legal authority is a pertinent comment on the limits of judicial review. So judicial review may be creative, may be activist, but there are controlling aspects to it. There are limits to judicial review, and that attachment to legal authority will be the limit. But quite often easier said than done, but we're looking at philosophy, you're talking about approach, given certain fact situations, a judge who is true to his duty, to his oath of office, will have to balance the competing claims and come to a just decision based on or latched onto legal authority. Now, what is the current position? And I've taken the audience to the 60s, or 70s, 80s, 90s, and at the beginning of the 21st century. What is the current position? You can say that the high point in judicial creativity or activism, you can choose the term of your preference, was reached in the trio of federal court cases. Again, most people who studied it were very happy that finally we see great movements in Malaysia. Semuanya Jaya, which was decided after I retired from the bench. Semuanya Jaya versus Pentadbir Tanah, 2017. Indra Gandhi, anak perempuan Muto versus Pengarah Jabatan Agama Islam, 2018. Alma Nudo Atenza versus PP, 2019. You have this cases which came one after the other, and they were good decisions, applying great jurisprudence in line with whatever was happening in the other parts of the world. Let me just look at Alma Nudo Atenza. Again, to the lawyers, you will know that this was a case where the double presumption under Section 37A of the Dangerous Drugs Act 1952 was struck down. Most of us thought, even before it, that this double presumption is no good. It leads to injustice. And sure enough, the court lived up to that expectation in Alma Nudo Atenza. To arrive at that decision, to strike down Section 37A, the federal court, had a very strong endorsement of the doctrine of separation of powers. So no more of this very glib view that whatever Parliament decides, we take it for granted as the correct proposition. They endorsed very strongly the doctrine of separation of powers. And Richard Malanjun, CJSS, I think this is one of his judgments before he retired, said very clearly, it is well established that the Constitution has to be interpreted in the light of its historical and philosophical context and fundamental underlying principles. Something most of us take for granted. You have to look at the philosophical context. You have to look at fundamental underlying principles. Law, particularly constitutional law, cannot be interpreted and applied without looking at its philosophy. and looking at the underlying principles, the fundamental underlying principles. So Richard on June CGSS did this so admirably, made it clear in Alma Nundo Atenza that this should be the proper approach. And he also said separation of powers is to be taken for granted as a constitutional fundamental. Again, very strong statement, because there was another justice who said the constitution, the separation of powers doesn't exist in the federal constitution. So I think it was good for Justice Richard Malinjun to come up with this statement. Separation of powers is to be taken for granted as a constitutional fundamental. And as Justice Richard Malinjun went on to say, the separation of powers, SOP, separation of powers is a hallmark of a modern democratic state. Views which are modern, which are good, which support and buttress the governance of this country as a democratic state. Now, so, and of course, this is also something which is taken from the same case. The court decided, this court has on several occasions recognized the principle of separation of powers and the power of the ordinary courts to review the legality of state action are sacrosanct and form, not from, sorry, there's a mistake there, and form the basic structure of the federal constitution. And Justice Richard Malinjun referred to Semenyih Jaya and Indira Gandhi. So that's why we have the trio, Semenyih Jaya, Indira Gandhi, and then we have this case on Atenza, three great cases. And here we have, head on, we meet the basic structure of the federal constitution. No running away from it. When you say something is fundamental, we are looking at the basic structure doctrine. And this is what the court said. In fact, courts can prevent Parliament from destroying the basic structure of the federal constitution. Something which is taken from the other celebrated case of Sivarasa Rasya. And the court also said, while the federal constitution does not explicitly explicate the doctrine of basic structure, what the doctrine signifies is that a parliamentary enactment is open to scrutiny, not only for clear-cut violation of the federal constitution, but also for violation of the doctrines or principles that constitute the constitutional foundation. Personally, I applaud this decision. I don't see anything wrong with this statement. In fact, this is the correct statement that one should support when one looks at the proper approach to constitutional interpretation. Well, it's a personal view. But of course, all these subtle principles have now been reversed by the latest federal court decisions, most of them by majority judgments, which may be good, which may be, I do not know. It leads to quite a lot of uncertainty at the moment. But these are all majority these judgments. You look at the list of cases, starting in 2020, so we're still living through this epoch. Maria Chin, Ketua Pengarah Immigration 2021, Ravi Jyoti, Kodeswaran, Lembaga Pencegahan Jenayah 2021, Letitia Bosman 2022, started from Letitia Bosman. Dato Seri Anwar Ibrahim, Usul Kerajaan Malaysia 2021, and the latest, of course, that I can find, Zaidi Kanapiah versus ASP Khairul Ridwan, and others versus other appeals 2021. So within 2 years, these settled principles have been reversed by majority judgments. So let's look at Zaidi Kanapiah. What does it say? So we look at the majority decision. So I take an excerpt from the judgment of Hasnah Muhammad Hashim FCJ. Let me read it because it's so important. As I have alluded to the doctrine of basic structure, doctrine of basic structure was and had been extensively argued by the parties in both Maria Chin and Rovin Jyoti. the court looked at these cases. In both of these appeals, this court, meaning the federal court, was aided by the written submissions of amicus curiae. Even if the parties were in consensus that the doctrine is applicable or otherwise, this court is not entirely precluded from construing and ultimately deciding on the issue before it. In light of the clear and purposeful intention of the architects of our constitution, as well as the judgments of this court in Lo Kui Chun, Pang Chin Hock, and more recently in Letitia Bosman, Maria Chin, and Robin Jyoti, the inevitable conclusion would be that the basic structure doctrine has no place in Malaysia. It therefore follows that the majority decisions in the aforementioned cases affirm the true position of the law and thus binding. So we have a very clear reversal. Those earlier cases applied the basic structure doctrine. In fact, if you look at Maria Chin decision, even the AGC acknowledged that the basic structure doctrine applied, but the court took a different view, despite the concession by parties. So there you are, that's Zaidi Kanapia. And of course, as expected, the trio of cases was distinguished. The amendment to Article 121 of Federal Constitution was upheld. 121 came up for discussion and resolution in Maria Chin. So all the cases by majority said the amendment to Article 121, which took away the express provision on vesting of judicial power in the courts, was good. And the court held that despite the amendment, the judicial power of the courts remained intact. Surprisingly, that was held at courts, remained intact. Lo Kui Chun was referred to and applied. This is a very old case, it's 1975. Remember, Lo Kui Chun was a case involving the right to a passport, freedom of movement. You want to do, don't leave the country, go to Australia, I think that case. The court held there was no such thing as a constitutional right to a passport. It was a privilege or something to that effect. But in the course of which, the distinction between the power of parliament and the jurisdiction of parliament and the jurisdiction of the courts was stated. And I will come back to Lo Kui Chun at the end of the presentation. Basic structure doctrine was rejected, and the court held questions of policy are for parliament to decide. There's no business of the courts to decide on policies. Leave it to parliament. And courts, of course, ought not to enter the political thicket. The very famous aphorism or whatever phrase that we find. Courts should not enter the political thicket. As if the courts always entered the political thicket. Never been the case that courts entered the political thicket. Courts will often look at the judicial ticket, the law. So the majority judgment was concurred to by Zaliha Yusof, FCJ, and Vernon Ong, FCJ. So a majority decision. There is a strong minority judgment, two strong majority judgments by the CJ, Tengku Maimun CJ, and Rosaria Bujang, FCJ. So this is interesting because you can see the stark differences in approach between the majority and the strong minority judgments. This is what Tengku Maimun CJ said. Article 4 cannot be subservient to Article 159. The others took it the other way around. 159, if the Constitution allows an amendment, then it is good. But of course, the minority says, no, it's not good. Article 4 cannot be subservient to Article 159. Very simply, because Article 4 reads, this Constitution is the supreme law of the Federation. And any law passed after Merdeka Day, which is inconsistent with this Constitution, shall, to the extent of the inconsistency, be void. Nothing can be clearer than that. But of course, it depends on how the interpretative process is taken. If you say 159 overrides Article 4, then of course you get a different result, a different approach. But CJ, Tengku Maimun CJ said, no, the right approach has to be Article 4 cannot be subservient to Article 159. And CJ went further to say, when you look at Article 121, you look at the spirit of 121. The spirit of Article 121, read in conjunction with Article 4, Clause 1, does not render the judicial power obsolete. Still exists. There is no such thing as there's no separation of powers. Does not render the judicial power obsolete. Otherwise, the federal constitution will not be maintained as the supreme law of the land. It's very logical, very easy to understand. And of course, the term federal law in Article 121, Clause 1 includes a constitutional amendment. No one quarrels with that. It includes a constitutional amendment. But nonetheless, that constitutional amendment can be similarly struck down under Article 4, Clause 1. The federal law itself must be valid law, as tested by Article 4, Clause 1. So Article 121, Clause 1 cannot be read as subordinating the courts under the executive or legislative branches, which is what the majority judgment seems to indicate. And of course, the majority judgments by Tengku Maimun CJ and Rosaria Bujang FCJ repeat the minority approach taken in Maria Chin and Rovin Jyoti. Let's look at, for good measure, the decision in Maria Chin. We'll look at the majority opinion first. Now, in that case, Raman Sabli FCJ delivered the main opinion. And you will see in the sentences highlighted, there's some alarming propositions, but I'll read all, the entire excerpt all the same. Article 4, Clause 1 of the Federal Constitution safeguards the supremacy of the Federal Constitution by preventing Parliament from passing any law it pleases, and the provision only comes into play where there is inconsistency between any post-Merdeka law and the Federal Constitution. And the inconsistency is irreconcilable with the terms and relevant articles and the terms of the relevant articles of the Federal Constitution. Article 4, Clause 1 has nothing to do with judicial power of the Federation. What the majority judgment indicates. The judicial power of the Federation is governed by Article 121, Clause 1. The article that the post-Merdeka law is inconsistent with must relate to the relevant subject matter and legislative scheme of the impugned law if the law is to be declared void under Article 4, Clause 1. In the present appeal, the appellant's complaint was about her right to travel under Article 5, Clause 1, but she had conflated the issue with an alleged breach of a right to freedom of expression under Article 10, Clause 1. Likewise, Article 4, Clause 1 cannot be invoked to strike down any law that is inconsistent with itself, as the article does not operate by itself and on its own. It must be read in conjunction with any other relevant article of the Federal Constitution. Thus, if Section 59A of the Immigration Act is to be declared void, it is void not because it is inconsistent with Article 4, Clause 1, but because it is inconsistent with Article 121, Clause 1. I find this very difficult to follow, quite honestly. I find it difficult to follow. Article 121, Clause 1 is unlike Article 4, Clause 1. But anyway, here you have the majority judgment saying, no, you test it by looking at Article 121, Clause 1. And we have, of course, in summary, the next slide, I've given the summary. I don't think I've misread the summary. They seem to suggest that judicial power exists because Parliament confers it. Again, something which is very alarming. Let's look at the quotation. The court's function as a court of law is to decide cases that come before it in accordance with federal law, which is enforced at the material time. In this respect, Article 121 Clause 1 of the Federal Constitution is clear in that it provides that courts are established by law, including the federal court, And the court's constitution and the source of powers are derived from federal law. Federal law is defined by Article 160 Clause 1 to mean any act of parliament. Courts vis-a-vis judges do not derive their power in a vacuum, and neither can they create jurisdiction for themselves. This is for parliament to decide by the passing of federal law when Article 121 Clause 1 states, and the high courts and inferior courts shall have jurisdiction and powers as may be conferred by or under federal law. We had established that Parliament has a legislative power to enact federal law in relation to preventive detention under Article 149. Section 15B of POCA is federal law, and that is where the courts derive its power in judicial review under POCA. This is premised on Article 121 Clause 1. The court's duty is to interpret what is provided in Section 15B. The powers of the courts cannot be derived from some amorphous concepts or doctrine, more so when such doctrines or concepts took root from a foreign country. Hence, it is incorrect to state that Section 15B is an attempt by Parliament to suppress constitutional powers given to the courts as provided under Article 121 Clause 1. The exercise of judicial power does not begin until and unless the court is called upon to do so. Such power exists because Parliament enacted to be so. Otherwise, the question of removing judicial authority does not arise. This is what I say in summary. They seem to suggest that judicial power exists because Parliament confers it. And there is a further twist to the majority judgment. There is a novel twist to the basic structure doctrine. And this is what it seems to suggest. The basic structure doctrine established the principle that the Constitution can be amended, but not its basic structure, as Parliament's power to amend is not a power to destroy. Applying the basic structure doctrine, the vesting of power in Parliament by Article 121 Clause 1 to legislate on the parameters of judicial power must also be treated as a basic structure of the Federal Constitution. And being a basic structure, it must remain forever in the Federal Constitution and cannot be removed even by recourse to Article 159. Very novel. So what you're saying is, it's a foreign doctrine, basic structure, but if it exists, then that doctrine also includes this limited power, limited judicial power by Article 121 Clause 1. There you go. I mean, something to think about on what is a basic structure and what is not a basic structure. And of course, at the end of the day, whether you look at Marichin or the other cases which have been decided recently, we are back to the ballot box remedy argument. Very old argument. We hark back to the 1960s. Yeah. Lord McNaughton in the Vackers case and a whole lot of other cases in the early days of judicial review. So this is what I say. We are of the view that what was said by Lord McNaughton in Vackers case is valid even in the Malaysian context. It is not in dispute that the duty of the court is to expound the language of the law in accordance with settled rules of construction. Policies of laws are certainly not within the province of judicial tribunal. It is with the executive. The remedy or the fear that the legislature may legislate laws which are unreasonable, unacceptable, cruel, or harsh, or that the wisdom of those in the legislature in question lies in the ballot box, not in the courts being creative and resourceful in amending the laws, for the simple reason that it is not the function of the courts. Hence the words of Lord McNaughton. Those who find fault with the wisdom or expediency of the impugned act and with various with vexatious interference of fundamental rights normally must address themselves to the executives or the legislatures and not the courts. They have the remedy at the ballot box. Rings true to its form to a large extent. So I call that the ballot box remedy argument, which has been resurrected recently. So I think one must look at the minority judgment with some seriousness. So I have actually touched on this point, supremacy of the Federal Constitution under Article 4.1 and its corollary device of judicial power are basic features of the Constitution. Accordingly, the power of the courts to scrutinize the state action, whether legislative, executive, or otherwise, cannot be actually formed basic structure. Because Maria Chin concerns ouster clauses, yeah? This was an attempt by the minority judgment itself to strike down on ouster clauses. So I've given the excerpt in the next slide. Yeah? They're looking at 59A of the Immigration Act, and the minority held that it should be regarded as invalid and unconstitutional. All right, so I think I'll skip that because I've already taken this point. Judicial review, in the minority's opinion, is an integral feature of the Constitution. All right, so again, I think I'll skip that because I already dealt with it. And the next slide, I think is important to bear in mind. The summary which I've given is thus: judicial power is not derived from black letter law. And this is what the minority sets up to say. The principles set out in Semenjaya Jaya and Indira Gandhi are irrefutably clear. Right? And I think I will skip the full excerpt in the interest of time. But I would also like to refer to that the resounding minority judgment of Nalini Ramanandan, FCJ in Rovin Jyoti. You're looking at Maria Chin just now, but we must also look at Nalini's FCJ's judgment in Rovin Jyoti. So I would like to read the excerpt in full, because I think it gives a good approach to the notion of the judicial function. Article 4, Clause 1 of the Federal Constitution enshrines the ability of the judiciary to entertain a challenge in respect of any legislation or statutory provision enacted by Parliament. It must be the judiciary that is armed to ascertain constitutionality, as such a function does not fall within the purview of the other two arms of government. It follows from this that any or all legislation, and therefore statutory provisions of legislation enacted by Parliament, can be made the subject matter of challenge under Article 4, Clause 1 of the Federal Constitution. This was clear from the second part of Article 4, Clause 1 of the Federal Constitution, which provides that the law that is inconsistent with the Federal Constitution is void. It is not possible to ascertain whether a law is consistent or inconsistent with the Federal Constitution until and unless a challenge is made as to its constitutionality on the basis of Article 4, Clause 1 of the Federal Constitution. So to enact a law which precludes application of Article 4, Clause 1 of the Constitution would defeat the very objective and purpose of the article. Article 4, Clause 1 of the Federal Constitution would be rendered odious. In other words, there must be a means of challenging the law in question, failing which the purpose and effect of Article 4, Clause 1 of the Federal Constitution would be nugatory. I like this excerpt because it sets out in very clear terms, in very logical terms, why we should give primacy to Article 4, Clause 1, and not Article 121, Clause 1. So, in fact, Justice Nalini went on even further to say, even law passed under Article 149 can be challenged because of the wording of Article 4, Clause 1. I will just leave the slide there. It's there for everyone to read. Yeah, it makes a lot of sense. So I will end by posing this question: in Malaysia, whether judicial activism, which is on the next slide now, where do we go from here? From the 1960s approach of strict literalism, from Karam Singh Lianage versus Queen Lim Kit Siang, to the liberal organic approach in the mid-1970s to 1990s, Dato Menteri Othman Baginda, Nordin Saleh, Pang Ching Hock, Lok Wit Chun, and the strengthening of the judicial function in early 2000, Nasir Hashim, Sivarasa Rasya, Lee Kuan Yew, Dharma Surya, Muhammad Hilman, Nick Nazmi, reaching a high point in 2017, Semenyak Jaya Indragani Almanundo Atenza, we are now witnessing a backtracking since 2020 through the cases of Letitia Bosman, Maria Chin, Rovin Jyoti, Anwar Ibrahim, and Zaidi Kanapia. To the approach approximating to 1960s and early 1970s, where parliamentary supremacy seems to be an accepted judicial philosophy. And we see the return of the ballot box remedy argument and a strict literal approach underlaid by an originalist philosophy. Why do I say originalist philosophy? So it's not really a straightforward literal approach. It is overlaid by an originalist philosophy. The majority judgments seem to refer the Reid Commission recommendations to support the conclusions. My problem with that is there is very little materials to pinpoint exactly what was the view taken by the Reid Commission on this matter of judicial review. But you want to be true to the originalist school, that this is what the Constitution was drafted to mean, and we apply what the Constitution has drafted, original meaning today. Yeah? But I don't think, if you read through the Reid Commission report, I don't think there is any statement to say that the courts should shy away from judicial review. I don't think so. Through my research over so many years, I don't think there is anything in the Reid Commission report or the supporting documents to say that courts in Malaysia must adopt a literal view, a non-creative view of the judicial function. In fact, you'll find that it is the reverse. I can't imagine Ivor Jennings, who also had a hand in the deliberations, or Lord Reid, who have adopted such a view in 1957. But anyway, so just to highlight my summary of what's happening now, it is a literal view that's being taken, a narrow view overlaid by what seems to be an originalist philosophy, as Americans would sometimes call it. You refer back to the Constitution, you look at the original intent of the Constitution. So I pose the final question before I end. Are we firmly back to the Lo Kui Chun philosophy? 1975, yeah? Those who find fault with the wisdom or expediency of the impugned act and with the vexatious interference of fundamental rights normally must address themselves to the legislature and not the courts. They have their remedy at the ballot box. I think we forget, maybe some of the judges forget, you have the word normally. Normally must address themselves to the legislature and not the courts. For someone who've had the fortune of being the Speaker of the Dewan Rakyat and seeing, how the legislative function actually functions, yeah, and having to think about collective wisdom of the legislature, I think one has to be a bit more realistic, a bit more modern in one's approach to this whole notion of deference to legislative authority. I end by giving you an anecdote. I think in another webinar, I mentioned this to Sri Hisham as well. I was presiding when the amendment to the Peaceful Assembly Act came up for discussion. Yeah? Of course, in Nick Nazmi, I was on a panel which held that provision, famous provision, unconstitutional and void. So what happened thereafter? Yeah, when I was sitting, there was an amendment, another amendment to the Act. And that provision on which we held the notice period unconstitutional was also amended. So instead of 10 days, I think they whittled it down to 5 days. Yeah? Of course, this is how the system operates. The courts will look at it. If there is a problem, they see that injustice has been done, that it doesn't conform with the Constitution, they strike it down. But there is nothing to stop Parliament from revisiting it and amending the law again to say, no, all right, if that be the case, we will shorten the period to 5 days. And possibly if it comes up before the court again, another court will say, yeah, we think 5 days is reasonable as opposed to the previous 10 days. And so that's how the system operates. checks and balances, give and take, balancing here, balancing there, and all aimed at good governance. Which is why I think I should end by saying that really the judicial function cannot perform its proper role if one adopts a strict interpretation, originalist as it may be. There has to be creativity, although not activist in the sense of what I mentioned earlier in that excerpt by Justice Vernon. Of course, judges do not decide politically, do not decide on the basis of political activism, but there is a strong case to be made for judicial creativity or activism. Yeah, if you don't like the word activism, then of course we'll look at the function as judicial creativity, and it doesn't run counter to what one assumes to be a proper discharge of judicial duty. And I think I end there. Apologies for taking a bit too long, because this is a large topic, and I had to cover all the areas. Thank you.
Thank you very much, Judge Ariff. It is indeed a very bulky topic to talk about, harking back to the 1960s all the way to the present day. And I think the audience have a lot of burning questions to ask both our speakers. I think I'll start with a question regarding the fairy tale. Judge Hisham has said that it is a fairy tale to say that judges do not make law. So whether it is a good idea to openly debunk this fairy tale, to openly acknowledge judicial activism, wouldn't it embolden judges to be more ready to depart from the black letter of the law? I think maybe I'll start with Judge Hisham first.
I think a myth is a myth, and it's a myth. It must be debunked as soon as possible. I think it's already been debunked as early as, if I recall, by one of the law lords just mentioned earlier, in the year 1972. So a myth has got to be debunked as soon as possible, and shouldn't be allowed, shouldn't be perpetuated. In any case, few lawyers today describes that subscribes to the view that judges do not make law and that judges are mere interpreters of the law. In fact, today, the judiciary in whatever jurisdiction subscribe to judicial activism, only that the degree of judicialism vary from one jurisdiction to another. The activism in India might not be the same as judicial activism in the UK or even in Malaysia.
Sri Ariff,
I fully agree. It is a myth. Who in his right mind will still believe judges do not make law? I mean, there are volumes of books on it. So we should call a spade a spade. Unless you don't believe in common law. Created by judges.
Yeah, I think, yes, calling a spade is right. But there are judges, especially in the Indian jurisdiction, such as Judge Pandian's view, as pointed out earlier, that when the apex court thinks that the executive and legislature fail to discharge their constitutional duties, the apex court would have no other choice but to step in and direct them to discharge their duties. The question is, should the Malaysia adopts this kind of view? Perhaps this time I'll start with Sri Ariff first.
Yeah, I don't really subscribe to that view, frankly. Because that is the Indian jurisprudence. Indian jurisprudence is also vexed and changes over time too. This is the tipping point. between performing a legitimate judicial function and tipping over to political activism. Right? We see that not only in India, but also in the Philippines. In the celebrated Manila Bay case, you know, where the court issued mandamus and injunctions, whatever, to compel the executive to clear up, Manila Bay, as part of, kind of environmental concerns. I don't think courts should go that far, right? But in a proper system of parliamentary democracy, such problems which are really laden with policies should be taken to Parliament. Right? You see, we and Wells were talking about the judicial function and how to improve the judicial function, talking about a proper approach. At the same time, one must look at the legislature. The legislature itself is not perfect. You got to improve the legislature too, just as you're improving the judicial approach amongst judges. And problems like this should be channeled to the legislature, reform in a way that the legislature can seriously tackle issues of pollution, issues of policy concern, more legitimately and more effectively. Courts, of course, can do it. That is, Indian courts have done it. So, but I fear if you issue a mandamus or an injunction, an executive refuses to act on it, what are you going to do? And how is a court going to monitor? Let's suppose you issue a mandamus to clear up Sungai Klang. How is the court going to monitor? You can't have judges occasionally visiting the site and looking at the rubbish which are not cleared up. No? But that is a matter for Parliament and for parliamentary committees and whatever that you can think of to tackle. So I don't quite agree with Justice Pandian's statement. I think it's a bit too overreaching.
Judge Hisham, would you have anything to add?
Yes, I agree, Tan Sri, that the Indian usually tends to overreach at times. But to be precise with your question here, there are two branches of government mentioned by Justice Pandian. That is, just like to elaborate what Justice Ariff has said. The executive and the legislature, and there's also mentioned by Justice Pandian of a failure to discharge constitutional duties. Now, a failure to perform a statutory duty is a serious matter, but a failure to perform a constitutional duty is a more serious matter. I shall begin with the duty of the executive to perform its constitutional duty. Yeah? In as you all know, in our country, if there's a failure on the part of the executive to perform its duty, then there is a remedy in it under Section 25 of the Court Judicial Act, right, with the schedule, the power of the court to issue a mandamus to compel a statutory authority to perform a statutory duty. But when the court does so, it is not exercise. It is not being judicial activism because it's prohibited for by the law. And now, but I would recommend that our courts be a bit liberal on the issue of local standard. At the moment, kita ni very strict on the issue of local standard. And I remember in one case where I sat with Tan Sri Ariff in the case of the Tamil school discrimination case, where we sort of expand the principle of local standard, where as a lawyer, Manoharan and lawyer Usai Kumar, they sued Dato Seri Najib, Usai Kumar against Najib, that there's discrimination by the federal government in allocation of money, finance, to Tamil schools. They say Tamil schools are not given money, same like any other school, or even they're given a very meager. But the AG countered. They said, look, Mr. Manoharan and Mr. Kumar has got no local standard. Reason? Because they have got no children attending Tamil schools. All right. So we accept the argument. They have nonetheless local standard because the complaint by these two lawyers, Mr. Othakoma and Mr. was that there is a violation of the federal constitution by the government, a violation of Article 12, right to education, and a violation of Article 8 of equality for law. So it says when there's a violation of the constitution, that the aggrieved parties, that in order to establish local standard, do not have to show that they have a direct interest in the matter. So on that day, I think that Dato Seri and myself and another member of the panel, we expand a little on, we were rather liberal on the rule of local standard to do justice to the case. That is on the act of Executive Act. But back again to the point made by Dato Seri, we shouldn't follow the Indian courts. There will go a point of bad points. The good ones are, for example, the case of Ananda. Basic structure, well, it's commendable, but sometimes they're rather a bit too far. And I can give you an example where the Indian courts, Supreme Court went a bit too far. And it's a case of Vishaka against the state of Rajasthan. And there was a complaint to the court for failure on the part of the Parliament of India to pass legislation to control or to prohibit sexual harassment in the workplace. So the Indian Parliament rather dragged its feet or rather refused to pass any law to protect women in the workplace. So they went to the court and complained. So this is what the court decided. I should read that is a case of Vishaka against the state of Rajasthan. The court says, quote, in view of the above and the absence of enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment at workplaces, guidelines and norms are hereby laid down for strict observance. So the Supreme Court laid down guidelines and norms for strict observance. This is done in exercise of the power available under Article 32 for enforcement of the fundamental rights, and it is further emphasized that this would be treated as the law declared by the Supreme Court under Article 141 of the Constitution of India. It's a clear case of judicial legislation and usurpation of the power of legislature. But you're talking about India. In India, the public take it well. Yeah, it's supported by the public because there is lacking of efforts on the part of legislature and to pass such a very important law. So there was public support. Although you can see that the usurpation of the judiciary of the power of Parliament, of course, it is not recommended. That I think our courts will never adopt such an approach. Well, that is Executive Act. But when it comes to legislature, it's a different consideration. The courts will be extending its powers if it wants to compel Parliament to pass a particular legislation, no matter how desirable the legislation is. Even the Indian Supreme Court, in the recent case called Uniform Civil Code case, has refused such a power. In Malaysia, example, there's a public demand that we have to pass a law to prevent party hopping. We have to pass a law to abolish the death penalties and all that. Yeah, but if an aggrieved citizen were to bring it to our judiciary under public litigation, it's very unlikely that the Parliament, very unlikely that our courts would entertain such a request for. That would be transgressing to the realm of the legislature and would be a violation of the principle of separation of powers. Yeah,
I think two very clear points is answered here. First is that the court should be liberal in terms of local standard, so that the cases can go can be more easily subject to the scrutiny of the court. But at the same time, if questions concern the issue of policy, ultimately the Parliament will be the better judge and with the better resources to decide on questions of policy. If that answers the question, then I'll move on to the next question, which some of our audience has expressed interest in as well. So, as judicial activism enhance the role of judges in the public life, whether it will be a good idea for potential judges to undergo a confirmation hearing in the Parliament, much like what's happening in the US, in order to boost public confidence. And if that is not a good idea, what should we propose? What kind of change should we propose to the Judicial Appointment Committee? So there's two parts to the questions. Maybe Judge Hisham would like to start first.
On the first part of the question about subject to scrutiny by Parliament, I think it won't be a good idea. And in the event, I don't think, and I think Tan Sri Ariff would agree with me, I don't think our Parliament is ready for that. Yes. But on the second part, I think something could be done to improve the Judicial Appointments Commission. Bring it to the level of instead of a mere act of Parliament, bring it to the level of a constitutional provision. So so it is at par, and I think we have to expand the composition of the JAC. At the moment, it is rather the judge with 5 judges and only 4, the 4 eminent persons. So it is rather a judge heavy. And the other thing, we still have that nagging provision in the constitution that that ultimately, whatever it is, the Prime Minister has the last say. I am for the proposition that we have to take up the role of the executive and the appointment of judges, so that once the JAC has made a recommendation and coming up, but the composition of JAC has got to be expanded, maybe to 15 or so, and have more, have also some lay appointees, not all lawyers. In England, the chairman is a lay person, so we have to have more lay person on board, and if possible, have some being appointed through election, public appointment, not being appointed by the Prime Minister. In England, some of the appointees of the minister are appointed on a competition basis. You have to apply, and there's a committee that appoints you. Well, but come back to the other point, I think whatever decision made by the JAC should go direct to the common rulers and the king. And I think there shouldn't be a supervening role of the executive, in the form of the Prime Minister, who can veto such appointment. Well, that's my view. Yeah.
Sri Ariff?
Yeah. I agree with Justice Hisham on the first point. In fact, even the second point, I wholeheartedly agree. Of course, our system in Malaysia cannot be the same, or cannot be expected to be the same as the US system or even the Indonesian system with its komisi. They exist in a presidential system. Here in Malaysia, it will not work. Imagine if you have a judge or someone who's nominated to be a judge being brought before a committee of Parliament to be questioned along the lines of a Senate hearing. I don't think we in Malaysia can take it. First of all, we don't have the expertise. Would you trust your MPs to do the job? No, not yet, or at all, because the system is different. Now, as far as the Judicial Appointments Committee is concerned, you see, it was mooted seriously. In fact, since more than seriously, it was part of the reforms that we wanted to do. The members of the Judicial Appointments Commission should be overseen by Parliament, meaning Parliament should have a say in approving the members of the Judicial Service Commission, or if not approving, at least to advise the executive, whoever will be the authority, that such a person is qualified or such a person is not qualified, so that you have this check and balance, overseen by Parliament. Only to that extent. Now, after that, of course, the Judicial Appointments Commission is expected to be independent in deciding who should be fit and proper to be appointed as a judge or to be promoted to the higher benches. Let them decide, free of executive interference. And I wholeheartedly agree with Dato Seri Hisham's comment on this. The role of the Prime Minister should be taken out of the equation. It's not right. It is improper, given the separation of powers, for the Prime Minister to have a say on who should be appointed and who should be promoted. Right? Let the Commission decide, and then eventually ends up, with the Conference of Rulers, and let them sort it out without any interference from the executive. But the people who man the Judicial Appointments Commission should themselves be men of stature and independent-minded, with some background in the law, in the legal service, judicial service, whatever. So with that, you should have a mixture. I agree. Many jurisdictions have this mixture, not only UK. You look at South Africa, they have this mixture too. There will be laypersons appointed. This is important. There may be people from the CSOs, civil society organizations, may want to propose a number of persons to also sit as a member of the Judicial Appointments Commission, and there you will have checks and balances. So yeah, I agree with Dato Seri Hisham's comments.
Yeah, so the key takeaways is that we do have a mechanism for a proper appointment of judges, that is the Judicial Appointment Commission, but it would be better if the composition is expanded and the quality of the commission itself is ensured, and to reduce the role of executive in the process. Moving on to, I think we have time for a last question. The question is worded in quite a lengthy manner. I will summarize it. So the question is this: written constitution is supposed to provide certainty, and countries like UK without a written constitution is supposed to have more room to maneuver in terms of abstract principles and moral reasoning. So in country like ours with written constitution, what should be the guidelines for judicial activism to be exercised? Maybe Judge Hisham can answer first.
Well, a written constitution is man-made. So, however hard it is for the drafters of the constitution to be perfect, it can never be perfect. At the end of the day, it will be open to interpretations. The court will have to interpret it. Yeah. But the court will have to interpret in the correct spirit. It cannot interpret as like Justice Dato Seri says, it cannot, like as if it is a will, or it is as if it is a normal act of parliament. It must be given a broad and liberal interpretation, in accordance with the history and the spirit of the constitution. And that's one thing. The other thing is, but when it comes to judicial activism, the judicial activist judge will have to interpret it within certain parameters. That is important. That's important. There is a parameter. The judicial activist judge, it doesn't mean that he's free to interpret it in the way he so desire. There is within a parameter within which he must interpret, and he must not cross the line. Yes. Yeah. What are the parameters? The parameters are, what does the provision say? What are the facts of the case? What does the constitution case? So he must bring in his understanding of basic principle of justice. He must also inject in his noble values and so forth. Yeah, that's my take on that. Yeah.
How about Tan Sri Ariff?
Quite often observers of the Federal Constitution of Malaysia take it that our constitution is very detailed, and hence you have the question. But actually, it's not true. The constitution is bulky and detailed when you look at the administrative provisions. You look at all the intricate provisions of federal-state relations, on land issues, and so on and so forth. That makes it very detailed. But as far as provisions relating to fundamental rights, let's say, the terms used are just as broad as any other shorter constitution. So in that part of the constitution, you have terms which require to be creatively developed. Right? And therefore, there's no running away from the creative function of judges. You cannot interpret those provisions in a literal way. It's impossible. If you interpret them in a literal way, you get all these abuses in the past. Whatever the executive decides is law, which again is not right, because you have to decide in accordance with the spirit and intendment and the basic principles underlying the constitution. Yeah. But of course, if you're looking at those parts relating to federal-state relations, about land issues, and even I don't know, there's so many parts of the constitution which are very, very detailed. Maybe a literal interpretation can be taken, but even so, I doubt it. You look at provisions relating to citizenship, for instance, very detailed. But there will be cases when you need to interpret it. You need to interpret what parent is. So hence, you have this creative function still in play. So, and the other part of it, I will agree with Dato Seri Hisham's comments on it. You got nothing further to add.
So I think the key takeaway for this question is that judicial activism truly shines when there are gaps in the law that needs to be filled in a particular case, and at the same time it has to be within the bounds, within the parameters. Although what exactly is the parameters requires a multifactorial analysis, but it should still be within certain confines rather than subject to the whims and fancies of the judges.
Can I just add something which I've forgotten? And it remains necessary for courts to work out the principles of interpretation. So far, we have just very few of them: presumption of constitutionality, for instance, and another presumption that you should be interpreting a provision more liberally when you are faced with a fundamental rights issue. But actually, if you look at the experience from India, for instance, just to take one country, there can be a whole series of principles of interpretation, which I think our courts have not really elaborated. So there is still the need on a case-by-case basis to work out what are the principles. And for academicians to look at it and suggest some principles of interpretation in a more detailed way.
Judge Hisham, so before we end, do you have anything to add to that?
No.
Okay. We apologize that we have run a bit longer than we've intended, but I hope that both our speakers' view has benefited you in these sessions. So do join us in our next session on the 3rd of December, where Judge Hisham will be joined by Dr. Prasad Abraham, to discuss about natural justice. Thank you very much to Judge Hisham, and thank you very much to Tan Sri Ariff. And
Thank you.
I hope you all have a nice day.
Thank you, Ariff.
Thank you, Hisham. Thank you. Good to see you again.
Yeah.